There's a phone number that ends in 8883. Can you please unmute your device and tell us your first and last name? It's star 6 to unmute. Hit star and 6 to unmute the device. 8883. Please hit star 6 to unmute your device. We can't call your case if we don't know who you are.
Hello?
Yes, please tell me your first and last name.
Well, my name is Benjamin Meyer, M-E-Y-E-R, unlike the paperwork that I've been sent. That it says M-Y-E-R. It is not me. I am here under duress.
Mr. Meyer?
Yes, ma'am. M-E-Y-E-R, not the person you had spelled on this paper.
Mr. Meyer, please stop talking.
Yes.
The court will call the case of the state of Michigan versus Benjamin Meyer, case number DIB 053809. Is that correct?
See what's for the people.
267659. Thank you. Mr. Meyer, you've placed your name on the record a number of times at this point. You're here for a contempt hearing today. Mr. Meyer, you owe this court $168. When do you plan to pay it?
I do not plan to pay it because I don't own it. Period. End of discussion.
Okay. Well, then what I'm going to do, Mr. Meyer, is find you in contempt of court.
And what you're going to do is find yourself in a 1984 federal lawsuit.
All right. Let's do it however you want to do it. You're found in contempt. You need to be here in person.
Absolutely not. I will not be coming to your court for any fucking reason.
Bench warrant to issue.
And what you're going to do is find a gunfight and a fight on the side of the fucking road.
All right.
This fine and fee was paid 10 years ago or more. Now you can either fucking listen or we can do this out in front of your court.
Mr.
This
Meyer,
fine was paid 10 years ago. Will not be paid again. You fucking damn near shot me and killed me. Are you fucking kidding me? Have you goddamn lost your fucking minds?
30 days in the Washtenaw County Jail. Keep it up. We'll go with more.
And we'll see you hung in front of Washtenaw County Jail.
All right. Threats. I'm going to report that to the Attorney General.
I'm reporting you to the fucking Attorney General. Are you fucking nuts?
Okay. Everything you're saying is being recorded.
You are a goddamn tyrant.
All right.
I called the goddamn fucking attorney's office and you fuckers rejected me. Are you insane?
3 days in the Washtenaw County Jail. Keep it up.
Oh, you'll find yourself in prison, bitch.
All right.
You think you're a goddamn king? You're a fucking tyrant.
90 days in the Washtenaw County Jail.
Below me, bitch.
All right. Then I need to call the jail and let them know that he made threats against me and anybody that's coming.
While we're waiting, I wanted to say I'm sorry you had to go through that. That's horrible.
Oh, thank you. I appreciate it.
I just said you have nerves of steel.
Andrew, I'm quite impressed by your composure there myself.
Thank you. Thank you. I appreciate it. It's I've never been threatened to be hung before, so I'm still processing that.
It was very alarming, Your Honor.
Yeah, it still is. So we're addressing that here.
Court calls case People versus Benjamin Meyer.
There's a hearing on behalf of the people, Your Honor.
Assistant Public Defender Ben Dunaway on behalf of Mr. Meyer, who is approaching the podium now. Mr. Meyer, would you please state your name for the record?
Benjamin Meyer.
Okay. And Your Honor, Mr. Meyer would like to demand his exam.
Okay, we're gonna have a problem. Council approach.
Worth because they have to find a judge that can do it because it's often the case. Yeah, that's all fine.
All right, record should reflect we had a bench conference in this case. In this matter, I don't have a problem setting it for preliminary examination. As I talk to counsel at the bench, it will be likely, given the circumstances of the case, that all 7 judges or district court judges will recuse. And so a judge has to come from someplace else to hear your case, sir. Okay. And so I talked with counsel so that it's going to be a logistical. There are certain logistics that are going to cause a problem, just to let you know. So what I'm trying to do is speed it up as much as I can, and hopefully get it done. So I've got 3 of the, including myself, I have 3 of the judges here in the building. Okay. So hopefully we can try to get those 3 signatures recusing today. And therefore, there are 3 others then from 15th. If they decide to recuse, that we would have to get their signatures. And obviously Judge Washington we'd have to get her signature, which I don't think is going to be a problem. So to get that process started, and while I'm laying that all out to you, I don't know if it's going to work that way, but I'm going to do my best. Okay.
Appreciate it.
I'll set the preliminary examination at this point for January 21st, 2025, 9 a.m. I'm going to set that before me. And then that way I can start that process and hopefully get that done. Okay. That's the best way. The other thing I'm going to note to you, and in setting it out to that point, I am finding good cause to do so, is that after all of that occurs, your date may get moved, not only because of the other judge, but also because the Judge Washington's docket, everybody's going to try to work around that.
Gotcha.
Okay, so I'm just trying to be as transparent as I can for you in terms of dates and everything.
Thank you.
Got it?
Thank you.
Thank you.
All right. So I'll do that. Bond will continue. And then we'll go that way.
Okay.
Okay.
I'll come
I need
to the jail next week.
need it set up. I need the form set up. And then try to get it to the administration to get it. Get the signature signed as fast as we can. Okay. You also understand, sir, that there can be great peril in representing yourself. I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
What do you want to do with them?
I would like to suppress them so that they don't hinder my trial experience.
Okay, sir, it doesn't, you seem to want this process to work away. It doesn't. Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Okay.
I think you really need to think about getting an attorney. That part of the motion is also denied. But I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that? You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. I'll grant your adjournment. Probable cause conference. Yeah, let me at least have some turkey before I have to deal with this again. December 5th. So folks, if you haven't figured out why, I'm going to take a brief break. To understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said?
I comprehend what you're saying, Your Honor.
Tell you what, I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat. And you might want to wipe that smirk off your face while you're doing it. Sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges.
Not my question.
I recognize what you're saying, Your Honor. I'm fully prepared to proceed with this matter. I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying.
I overstand what you're saying.
Have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had.
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. Sir, listen closer to my question. Do you understand that?
I do not understand.
Whether or not you disagree with them or not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor. Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything. I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m.
Your Honor.
or I will. Do not interrupt me.
I can object to
Do
that date.
not interrupt. Do not. One more time. You're going. I've given you fair warning. Bond will continue. You
Your
may
Honor.
leave now.
I have constitutional.
You may leave
violation.
now.
Let's go.
Mr. Allen, he is to be removed from my court. Court does call the case of People versus Daniel Magoo.
Absolutely.
Danny Magoo.
Ready for preliminary examination, or at least to deal with his motions? What are we doing?
Yeah, would the court be so kind as to make the self-representation inquiry? And
Yes.
perhaps we could look at the motion first?
Mr. Magoo, you are here before the court. You're set today for a preliminary examination. You're here before the court on the charge of resisting and obstructing a police officer. That's a felony, punishable by up to 2 years incarceration, $2,000 fine plus court costs. You appear here unrepresented as you have in the past, and the court has given you the admonishment regarding self-representation. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings you decide that you wish to be represented by counsel, cannot afford to hire counsel, then an attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right.
Thank you.
What are we doing?
I think defendant has a pending motion.
Yes. Go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, that there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make of that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state, and I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do, Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from the prosecutor. However, it must be corrupt or something. It's not going through. I'm trying to get a valid copy from her. But other than that, I believe I do.
That's correct, Your Honor. We did send over an audio file this morning, and I did see the defendant reply that he was having trouble playing it on both his laptop and on his phone. I will note it. I'm just seeing today, it looks like the defendant may have a MacBook, and I know that those can have a little bit more of a difficult time with some of the audio files that come from my office. So that may be something that, I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of?
I believe it's the 911 call that brought the officers to the scene, but it would not be an exhibit that people plan on playing at the preliminary examination.
All right.
I would like then to motion for a preliminary examination to get the officers in here on the record, then, Your Honor, please.
All right. Is there anything else you needed the court to deal with? You mentioned bond conditions. You say you have all of the discovery. There may be an issue with the playing of this one audio. Is that correct?
That's correct.
Anything else you're requesting?
No, Your Honor.
All right.
At this time.
With reference to the bond conditions, all of the bond conditions are standard bond conditions issued in every case. And so the defendant's motion to change his bond or the conditions of his bond is denied. The court does deem them appropriate and properly set by the magistrate. Does not see an abuse of discretion regarding that. With reference to the court doesn't have to deal with any of the discoveries. We have it with reference to the preliminary examination. I'm more than happy to give a preliminary examination date. I will grant the people's request to adjourn in this matter and would set it for the 21st, if that will work with everyone's schedule.
January 21st?
Yes.
That's fine for the people.
Fine for Your Honor.
Yes. So preliminary examination will be set January 21st. 2025, 9 a.m. before me. That's in person. Defendant's bond with conditions is continued. Thank you. Whoa. How the hell do you jump to that conclusion? Then you're going to need to file a motion so I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. How long is that going to take you?
Judge,
How long is that going to take you?
Judge, certainly.
How long is that going to take you? If you cannot answer that question, then I will take a recess. I will give you time to think about that. And then I will come back and I need your time frame for how soon you can file the motion.
Judge, respectfully,
No, you lied to me. If you're going to sit up here and tell me you didn't lie to me, you want me to play it back.
Judge,
Quite frankly, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recused for the purpose of forum shopping. Because there's no other reason, I think, to try to bring this frivolous argument. Court does call the case of People versus Wilson.
Ready, Your Honor.
People.
And good afternoon, Your Honor, and to your staff. May it please the most honorable court, Mohammed Nasser, P74485, appearing on behalf of Mr. Wilson, who appears standing to my right. Sir, please state your full name for the record.
Darren DeWine.
Judge, I'm also assisted by co-counsel Attorney Edward Martel.
And good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court. That is my also on behalf of Mr. Wilson.
And Judge, I also do have an advice of rights if I may approach.
Yes.
Thank you kindly.
All right, so what are we doing today? I have a plea form in front of me. Is that ultimately what the objective is?
It is, Judge. We've had an opportunity to talk to the fine prosecutor. We were able to work out a resolution. We respectfully request this honorable court to accept same.
There is, however, still the motion for my disqualification.
Judge, we're withdrawing that motion.
Pardon?
We're withdrawing that motion, Judge.
Any objection from the people on withdrawing the motion?
No objection, Your Honor. Thank you.
It started with a phone call. Benjamin Meyer, a sovereign citizen, dialed into a Michigan district court hearing for a simple contempt charge, $168 owed to the court. What followed was one of the most explosive courtroom meltdowns ever recorded. From the moment Meyer spoke, the tension was electric. He immediately challenged the court's jurisdiction, insisted the fine had been paid 10 years ago, and accused the judge of attempting to shoot him. Within 90 seconds, he threatened a 1984 federal lawsuit. The judge, unmoved, fired back with 30 days in jail. But Meyer didn't stop. He cursed. He screamed. He threatened a gunfight on the side of the road. He called the judge a tyrant. He told the court to blow him. With each outburst, the judge calmly doubled the sentence. 30 days became 90, before ordering Meyer removed from the call entirely. The judge, visibly shaken but composed, quietly admitted to fellow court staff, "I've never been threatened to be hung before." The courtroom fell silent. Then came defendant number 2, a man representing himself on a felony charge, filing motions with legal-sounding words that made no logical sense. The judge, already stretched to her limit, didn't hold back. Just because you use what seem to be legal words doesn't mean it makes sense. She threatened a competency evaluation. And adjourned the case, warning him bluntly to lose the smirk. 2 defendants. 2 spectacular implosions. 1 unshakable judge. The courtroom was a battlefield that day, and justice, cold and precise, won every single round. Speech balloon. What do you think? Did the judge handle this perfectly, or did she go too far? Drop your verdict in the comments below.